I'm here on that matter.
I was, when I first looked at it, is this anything on for this today? This looks like it's set into August.
So it is. It's on for a compliance review today. Compliance with the final orders had a 90-day clock to essentially pay out the final judgment or put the house on the market. So today was a day to set aside to review if he had done one of those two options.
Okay. All I had was a docket notice, so I don't. I saw there's a contempt motion filed for sometime in August, but I didn't have anything else filed, so I'm not sure what to do with this today.
If the court will give it, I would say if you just handle one or two matters and then come back to this, I'll see if opposing counsel appears because he hasn't withdrawn, I don't believe, in this matter, and then we can address it, I think, quickly and then move it off to that August date.
Okay. See, I don't see. Is Stephanie Lindsay? Not see her here yet. Do not appear to have her online yet. She did respond, and I saw. I guess my question is this a mediation issue under the parenting plan?
No, I don't think so. I think normally it would be, I don't think it is. I think you can decide that because it's limited to the one issue related to the summer schedule. They see that they've gone back and forth with that. She's already had her weekend for this past weekend. I think this is one that you could bring via motion, whether it's clarification or not. And again, with the timing of everything, that's been part of the issue with her deciding that it's, she's not going to comply with this agreement they had. Timing of that with the wedding being in 2 weeks, I think it needs a resolution now.
You saw the response, I assume.
I did.
So it's not clear to me what the agreement that where we're at right now.
Well, the agreement, then if you go back, so a little bit of context on this. You heard this back.
Mm-hmm. Remember the case.
It was in January, February, about the first of the year related to a parenting plan modification. Parties agreed to a week on, week off. That was entered back in, I want to say March 26th or thereabouts. They stumbled through that, orders were entered, those went out. Didn't specify, which again is not unusual, who starts with which week and when that commences. Nonetheless, my client around that time sets his wedding plans. They have the communication back and forth. Initially, they don't agree. And to your point, I think it's a good one. If this would have occurred, if they just never resolved the issue, I think you're right. That probably would have been a mediation topic. But the parenting plan was really never set into effect on whose week it was. So they're kind of dancing through that, trying to figure out on that week to week avenue, who got what time, who started that, and so forth. I think that becomes a moot point because then in mid to late April, they agreed, which worked out for both of them. I think the text communication that we've provided to you as an exhibit kind of verifies that, stating, and this was after a phone call, mind you. Now, my client texts his former wife, says we are, quote, trading July 25th through the 28th, 2024, which has happened. She did get this past weekend. For August 16th through the 19th of 2024, Stephanie can have the kids for Silverwood and Justin can have the kids for the wedding. She, one simple word response to that, agreed. So at that point, there is no real reason to go to mediation. There's no reason for anything because that's in effect throughout the spring. It's not until the middle of June or thereabouts where Mrs. decides, well, this isn't going to work. No, I don't want to do this. Mind you, she has taken her weekend last weekend. One of the kids, at least one of the kids, did go to Silverwood. The other one, I think, stayed home with mom. It was a family outing. My client honored that. I think the very information you have that, okay, we've agreed. At that point, there is no point for mediation. It's resolved. My client goes about scheduling the wedding, making those plans in typical fashion. That's rehearsal, that's dinners, that's the ceremony itself, that's the after reception, which she just unilaterally one day said, well, thanks for the weekend in July, but I'm not going to honor the weekend in August. So if you look at her response, which clearly he did, and she confirms this, saying essentially, hey, listen, the soccer takes precedent over father's wedding and those activities. And again, these are kids who are involved in activities. The daughter plays soccer. My client tells you nearly every weekend. So yeah, I mean, what he's requesting is certainly reasonable. If you look at the history of this case and how we got to this point, not just now in July, but back in January upon filing the modification action. This is pretty common, pretty typical for her. So here we are, and I think that was probably done largely by design on her behalf. Certainly impacts my client and his plans for the wedding, certainly impacts these kids and their ability to participate with dad in the wedding. And again, the fact that she took the benefit of that agreement, took last weekend, only to say, well, you're not going to be able to get your wedding, or I'll give you a couple of hours on your actual wedding day. Again, it's just nothing more than an inconvenience. So we are asking just for the bench order that the kids can attend dad's wedding and all of the activities leading up and after that, which we've identified for you as August 16th through the 19th, which again, directly referenced in that text communication that we gave you. Nothing in mom's response disputes that. She says, yeah, that's true. And we did agree with that. And I know that he made his plans accordingly, but I changed my mind because one of the kids was now on a soccer team, the Timber Bears or something like that. And therefore, because the kid likes soccer, that's going to trump whatever happens over dad. So that's where we are. That's the request. It's not time to get that into formal mediation by the time she basically whitewashed that agreement that they had made. We're just simply asking you to enforce that so that my client can go about in the next couple of weeks in peace, knowing that he doesn't have to deal with this nonsense of this ex-wife playing games under the schedule of the prior agreement.
All right, I just double checked. She doesn't appear to have logged in. She did file a response, and it does seem to indicate there was an agreement. So I'll sign an order that grants him that, essentially what the black bubble in this April 28th communication says.
You want me to draft that while you're going through stuff?
Sure.
We did ask for fees, any contribution towards that.
Check here just a second. I'll order 1,000.
Thank you. Payable in 60 days.
I'm just gonna order 1,000. I'm not gonna make a payment. I don't know our situation for payment arrangements. Okay.
Let's see.
All
I don't
right.
see Mr. Burnham. We did reach out to his office, both by email and by phone, and haven't received a response in either capacity. So given that, what I propose is this. The court should just note the non-appearance. This is contemplated by the final orders that there would be a compliance review. And we certainly have issues of non-compliance. Go ahead and set us to August 20th at 1 p.m. We were able to effectuate service, so that August 20th date will be appropriate.
Was there a specific provision in the decree for today? I know there was there's a docket notice filed.
Yes, it says 90 days. Originally, it's 90 days from the date of entry. So you have to look at Exhibit A to the decree.
It says on June 4th.
Yeah, by the time it was entered, though, that was too soon. That was earlier than 90 days. So then we pushed the data out to this date so that it would be past the 90 days.
Okay. All right. So I didn't have anything filed for today, so I don't really have any basis to do anything today other than I can note nobody's here. It did look like there's one issue having to do with a timeshare.
Mm-hmm.
And I'm not sure that that's even an order that could be enforced because I don't believe there's a way to remove somebody from a timeshare contract under those contracts. You know, they're horrible contracts, and they essentially last through multiple generations.
There was in this case, because that was what was presented as part of the agreement. So, in this case, there was a unique ability for him to exit my client. So given that, we would ask that the court just set us to that August 20th date.
It's already, it's noted on for that date. So it's back for August 20th at 1 o'clock.
All right, very good. Thank you.
On behalf of Miss Boyce, Your Honor, she asked that I appear for her today. She's on vacation.
Okay. I was trying to figure out exactly, there was a motion for genetic testing, and there was some other documents. I guess and I didn't have any response. So is there an objection to doing genetic testing?
There is, and here's my understanding of this. I did speak briefly on the telephone with Ms. Bliss yesterday morning. States that Mr. did file for a motion for genetic testing on June 28th, with a docket notice on 7/1, but Ms. Bliss and her office were apparently never served with anything. My understanding is she didn't know that the motion was even pending or what the request was until she searched, I believe, on Friday, Odyssey, and saw that some information had been filed and submitted by the alleged, or at least requested father on this. In looking at that, she did ask me to specifically detail for you that the docket notice that he did submit, and again, never served, lists the correct physical address and phone number for Ms. Bliss's law office, but has the wrong email address. Apparently it's not. So it's unknown what email he sent that to, if any. Nonetheless, she never received notice. She's asking that it be set over 3 weeks to accommodate her scheduling, and the fact that she never saw the motion until, my understanding is, Friday afternoon. I have no idea or input on whether she was able to discuss with her client or get input on that. So that's the request from Ms. Bliss. I'll leave it to your honor to go from there.
Sir, did you deliver copies of this motion to her office?
So I sent the email over to I got off of Google. I looked up her name and got her email off of Google, and I sent it to her.
Okay, well, you'd need to physically get the documents there unless there's an agreement for email service.
Okay.
So, I mean, you can do email if everybody agrees to it, but you can't do that as a default.
Okay.
I can set it out to 3 weeks. That'd be the sufficient time for normal motions. That'd be the 20th of August
Okay.
at 1 o'clock. So, it sounds like you don't need to file anything additional with her. She'll file some sort of response before then. She may be in touch with you if there's some agreement.
So I need to send another docket to her.
You don't need to send anything else to her. She's requesting 3 weeks. I'm granting 3 weeks, so we'll set it on for the 20th. Again, that's 3 weeks from today, 20th of August at 1 o'clock.
Okay.
And it'll be in this courtroom.
Okay.
Hopefully, it'll be one of the 3 courtrooms.
Okay.
Okay.
All right.
All right.
Thank you.
Very good. Good afternoon, sir. You're Joshua Pino.
Thank you. Good afternoon.
Good afternoon. So I looked at this and it, just so I understand where we're at procedurally, you'd filed the petition on this with the proposed parenting plan. Mr. Zandy filed a response and a motion for temporary orders, which is why we're here. And I didn't have a specific response to that other than some documents that were filed today. Is that accurate?
Yes.
Okay. So generally speaking, if you don't have something filed according to the court rules, it's about a week ahead of time for a response. I really don't consider it.
Okay.
So at this juncture, what I have is 2 proposed parenting plans that are significantly different from each other. And so, counsel.
Yes, and
it's your motion.
We're ready to proceed. I'll certainly give him a little bit of leeway in his comments if he so chooses to make any of the court. For the record, I do represent the respondent, Caitlin Langford. We are here on my client's motion for temporary orders as it relates to the care and support of 4-year-old Presley. And this is one where I think it's pretty easy to see in the pleadings, or at least based on the information provided to you from my client, that my client's really been the only parent in this child's life since birth. You look at a lot of the history of this. These parties met years ago, back in 2018 or thereabouts. Started a relationship, and that relationship was kind of founded upon drugs abuse and substances. My client details for you that around that time of finding out she was pregnant, she ceased all use of illegal and I think all substances in general, and she has a sobriety date of September 24th, 2018. So again, she's taken the whole parenting thing very seriously. She's moved on from that. We're going now on drug history that is far exceeds the life of the child. The child again is 4. Drug history for my client is about 6 years. Same can't be said for dad. And dad, again, you got this information from the watch report that we filed along with my client's communications with him via text message that we provided you for review, as well as other corroborating information that shows dad has largely assumed a life that's kind of dedicated and prioritized with criminal activity, including domestic violence, substance abuse, conflict with law enforcement and the like, and frequent incarcerations, which has put him in a position of not seeing his child. And again, when looking at the proposed parenting plan that was submitted by dad a couple months ago, it struck me as somewhat ironic. If you look at Dad's parenting plan, he's asking for very specific 191 factors geared against my client. He's asked that the court find my client has withheld the child. He's asking that my client be found to have been alienating the child from against Dad, neglect, substance abuse, and abusive use of conflict. If you look at that and you look at the communications back and forth, you look at the fact that this is an individual who's made absolutely zero effort to see his kid since April of 2022, I believe it was, at which time he wanted to get the child's social security card again, or at least number, for his own benefit of claiming the child assumably on taxes or for some other financial benefit. No effort since that time to do anything with this child. In fact, we've given you information from my client that shows not only has she offered visitation and tried to attempt to communicate with Mr. Pino, she's gone so far as to invite him to birthday parties, to holiday functions, for visitations. In one communication, she says, "I want you to be a part of his life," at which he's pretty much just kind of scoffs that off and says, "Well, when it's convenient for me, essentially, I will." One excuse, which I had never seen before, is that he had hemorrhoids so bad that that was going to impact his ability to go to the child's birthday party. He makes promises to see the child, never followed through on that. There was the incarcerations. There's domestic violence with the former girlfriends. There's now protection orders entered out against him. So to suggest that my client has been withholding and alienating him or engaging in abuse of conflict, again, just simply is not the reality. If you look at the communications from Mr. Pino to my client, again, it indicates an individual who has a lot of unresolved issues going on right now. It's an individual who was arrested, I believe, as early as this time last year for assault 3. You see the communications in which he admits to challenging jail staff and police officers to fights. You see information directly from him in which he says during one of the criminal hearings that the judge said he was a danger to society. You see communications in which he says and admits to beating on past girlfriends. You see all of these various types of communications, which him in his own words is telling you, I haven't been responsible. I haven't sought treatment. I haven't gotten beyond the issues that have plagued his entire adult life. So that's kind of where we are. So when we look at, again, an individual with that type of history, one of the pictures that we provided to you from a former girlfriend is where her eye is so beat up, it's almost swollen shut. See the bruising, and I know it's a black and white picture. I have seen the colored photo, and it's extremely bad. So he's done a number on that one. She's not the only one. There's been other cases in the past in which he has consistently beat on his girlfriends at the time, again, to the point of having 5-year restraining orders issued against him for contact with them. And what happens over the course of those 4 years? He rarely, if ever, sees his child. He's constantly putting that relationship on the back burner to pursue other interests, again, to be implicated in criminal matters, and again, to beat on his romantic partners and his girlfriends. So to suggest that my client is the one that has these issues, given the facts before you today, I would say is not only just extremely disingenuous, but not candid whatsoever with this court. We look at some of the other, again, matters of this. I think this is probably a case that is ripe for GAL investigation. At this point, it's not, does Dad have contact? I don't think he does. And again, he's virtually a stranger to Presley, who's now 4 years old. Hasn't seen this child in over half of this child's life. Hasn't seen him since April of 2022. And again, that was for about 20 minutes when he came to get some information from my client. So for him to suggest all of a sudden, well, I want weekends with my child and I want every single holiday for the next 5 years to make up for what I've lost, fails to recognize the fact that he's in this position because of his own choosing. And again, that's extremely problematic when you consider the domestic violence issues. I think that's pretty poignant when it comes to the pattern of ongoing abusive personalities. I think that certainly strikes close to home. And this is an individual who my client details for you in her declaration has absolutely zero control over his emotions. She tells you not only is there the challenging jail staff to fights and police officers to fights, there's also hair trigger type instances where he will get on a couch, rip his shirt off and bang on his chest, literally like I believe she says a gorilla when he's angry. This is well known. It's an individual who gets in fist fights with his, I believe it was stepfather or father at his mother's home. If you put all this together, this is a guy with a lot of questions, a lot of issues, and absolutely zero information in front of you that he's adequately or appropriately dealt with any of those. Prior to any visitation, we want to know if he's serious about this. If he wants a relationship with Presley, we welcome that. And my client has evidenced that throughout her communications with him. We gave you a sampling of those. in which she's encouraging him to come to these functions, encouraging him to build a relationship with his child. And unfortunately, he continues to do everything but to do that, to take advantage of her generosities. We're asking in the parenting plan, at least on a temporary basis, that he submit to a domestic violence evaluation with Olivia Lovely here in town, that he forward those results to the court and to my office alike, that he get a substance abuse evaluation. I think that's, given the history, certainly important. We would ask for a clean air quality test, again, or some evidence of sobriety that goes just beyond the comments of, well, I don't use drugs anymore, I've been clean. Also ask, and again, I think this is probably very important, whether that's now or whether this is later. I realize there's a cost to this, a mental health evaluation that has some form of a parental risk component to it. And this is not about my client, this is not about Mr. Pino, this is about 4-year-old Presley, putting him in a position around people who are going to be supportive of him. And until we can prove that the anger is not an issue, the domestic violence, the substance abuse, the estrangement from his kid, which was willful over the course of an extended period of time, until we have some assurances that those issues are resolved, are being treated, it's our position there should be no visitation. It's our position that we need to go through, probably because of the duration and the age of this child, some kind of reunification efforts, or family counseling. And we've suggested Charlotte Rosen. My client, I don't think is picky or particular about who provides those services. But again, we need to make sure that dad and child are in a healthy mind spot and emotionally for this relationship or the communication and contact to commence. And that's kind of where we're at with this. Would suggest, and again, I believe there may be an administrative order of child support. That's not my client's primary goal in this, but we are asking for a contribution in fees and costs. My client had to borrow significant money from family to retain my services. We are asking for $2,000 in fees and costs. We're asking for a time for that to be paid. It implies in Mr. Pino's parenting plan that he's working. He does reference work and work scheduling there somewhere. We just have no idea how much that is. So I'll let him certainly address that. But my client, in all reality, does not have the income to support legal fees, GAL fees, and the likelihood of this going for an extended period of time given the circumstances. So we are asking for that request. She's not currently working. The court is going to appoint a GAL. We would ask that that be county paid. Again, given the financial circumstances, as my client is going to have an extremely difficult time trying to round up the amount of money to retain the services of GAL. That's where we're at. And we certainly think it's in this child's best interest to proceed with caution. And again, because we have one parent who has been largely uninvolved, and we have a lot of questions as to what's going on in dad's life. That's the request. That's where we're at. I think it makes sense. And I certainly think it promotes the best interest of Presley.
Thank you. Mr. Pino, did you have any comments you'd like to make? I'm going to somewhat limit you a bit because I don't have a written response, but do you have anything you'd like to say, sir?
Okay, so in those documents that I turned in this morning, it shows that I have completed parenting classes. I have, sorry, I'm forgetting words. I'm in anger management right now. I'm in counseling, so I have compliance letters in there in those documents as well. I also have screenshots in those documents too. Basically, I'm not sure when you're going to be able to look at those, but it would help my case a little bit in this situation. Yeah, I do pay child support every month, and I have been for years now. I've been paying child support so much that I barely get by. So, I mean, that's not a big deal. Like, I don't mind, contributing to my son. I definitely want to see my son. Absolutely. And I have always wanted to see my son. I've been trying for years. In those screenshots that I've turned in, you'll see that I have tried to make an effort. And it's just after being told no so many times, or giving like certain, I don't know, she'd just tell me like, oh, you can have certain, you can see him at my house, type stuff, it's kind of tough and discouraging. Like, I would like to have my own time with him and, take him to the park, get to know him, but then so I was in his life, from his birth to 3, I think it was. And so like he knew me enough to where like he'd be okay to go to the park and stuff, you know, and bring him back, you know, a couple hours later, you know, whatever, after we get done having a good time. Well, you know, she wouldn't let me, you know, so it's just like after being, you know, told so many times, oh, I don't feel comfortable with this and that. He doesn't know me. Well, he does know me enough to, you know, call me dad and, you know, run up to me every time I come up to the house, you know, give me a big hug and stuff, you know. So it's just, it would hurt my heart, you know, after so long, you know, and finally figuring out how to do this parenting plan, I really struggled with that, you know, so it took me a minute to figure it all out. So I did end up doing that. Yeah, I did mess up a few times. Yeah, well, a bunch. I'm not gonna lie. Yeah, I have, but I also had turned my life around and try to do better for myself. And I think about my son every day. You know, that he's top of my list, my head, my brain. You know, everything that I do is because of my son. I just want to do better because of him. And I just had another kid. I'm pretty sure she's mine. So I've got supposedly 2 kids now to think about. And all I want to do is just work and be a father to both of my kids if I can. So yeah, in those documents that I turned in, you'll see that I'm trying and I'm taking it serious. So I don't really know what else to say. You know,
Yeah, it's just a couple of questions here. When was the last time you visited with the child?
I believe it was, I want to say Easter a couple years ago.
Okay. All right, did you receive these filings, Mr. Zandy?
I did not.
I don't know. You're welcome to look at them. I'm not putting a lot of credence on these. They do give me some information, which is, I think, germane to the situation. I'm not using that necessarily as, because they showed up today, I think. But I guess my feeling on this is that this is a case where I think we need a guardian ad litem ASAP to take a look. And I'd like to get that done and maybe come back in a month on some sort of a temporary recommendation. I'd be a little disinclined to enter a full parenting plan right now without some JL input, but we could put it in a temporary order that child resides with mom. At this time, no contact with dad until I get the JL report. So, and the reason I asked the question about when you saw your child last was, if it was 2 weeks ago, I might have a different opinion than a couple of years. So, obviously, there's a lot of information here. I do, I'm mandated by state law to look at the judicial access browser system, which is a database of people's criminal histories and case histories. And I have concerns on both sides, frankly. Your client has some dependency issues in her history. So that's, I mean, this is obviously not a black and white case. So, sure. But I think under the circumstances, I think getting a JL involved and getting that input will tell us a lot better kind of where we're going. Okay.
You're thinking a month out for that?
I would hope we could get at least some sort of a visitation type of a recommendation.
We want to, if we set this out for presentation, I know since things have changed in the last couple of years, we don't typically do like the old days where you hand write orders, but that might be appropriate given the timing in this case.
Well, I think we can do a JL order today.
Sure. You're good with county pay for
on both. I think he was unemployed based on this. So, but you
want a bench order that says pending this, what you just said, kid let
that. I think you could do a presentation. We could do that in a couple of weeks. I just want to get the guardian ad litem involved. So who's our next three?
The next 3 names for the GAL are Karen Lawrence, Keith Lawrence, and Twyla Corey.
I no preference on any of the 3. Okay.
And do you have any objection that we appoint them in the order top of the list? So you said Karen was first? Yeah. So it'd be Karen Lawrence would be the first choice. Keith Lawrence would be the second choice.
And what is this for, anger management?
I'm sorry.
Oh, what was this for?
This is for the guardian ad litem, the person who's going to look into your case and make a recommendation back to me.
Oh, okay, absolutely. Yeah, no worries.
Okay. Well, let's go with Karen Lawrence then at this point. She's first on our list. So we'll appoint her, and then let's put a review date. Let's try the 27th of August. That's 4 weeks out.
It's optimistic.
Well, we may be able to, if both parties are quick to respond to her, she can probably get us something at that point.
And you want like a full review date where visitation is addressed, or do you want that just to make sure that everybody's complied with meeting with the GAO.
I'd like to have some sort of visitation recommendation or not,
Okay.
depending on what her thoughts are at that point.
So I'll go out in the hall with Mr. Pino and draft this order and then bring it back.
Okay. And council, I'm gonna go ahead and give you this, and since you didn't see that, you can look at that. That may impact a little bit.
Did you bring this to my office, sir?
No, I actually have a copy out in the truck right now. I was gonna have one of my friends serve her
You can
today.
keep that. That's a bench cost.
Okay,
Yeah, so,
that's fine.
Don't worry.
all right, so head out in the hall with Mr. Zandy. He's gonna walk through the order, make sure it says what I just said.
Okay,
And then we'll come back on the 27th and we'll see if we've got a recommendation. It may take longer, but that's where we'll start it.
thank you, Your Honor. Appreciate it.
And I'm gonna reserve on fees, Mr. Zandy, at this point, but
Okay.
I'll take a look at that when we come back.
Thank you.
Ms. Russell, who's involved on behalf of the state. Yeah, Ms. Lawrence.
I'm here.
There we go. Great. Okay, thank you. And is Samantha Tina?
I'm here, Your Honor.
There we go. Okay, got everybody. All right. So did everybody receive a copy of Ms. Lawrence's report? Ms. Tina?
Everybody has it as far as I know.
Okay. This is a rather complicated case, or it's become a complicated case.
Yes, it has.
Um, at this juncture, I don't know that I have a motion before the court. Let me just double check here. It looks like there was a hearing with Commissioner Carmi on the 16th.
Correct.
So at this point, this is a very, I guess, a concerning case in the sense that after review of the report and recommendation, there's a whole lot of red flags that kind of fly up in my face. And then I did see a document filed by Ms. Tina on the 24th indicating that there was essentially agreement with that two of you breached some sort of agreement on 50-50 custody. And I know that would not be consistent with the report from Ms. Lawrence at the current time. So I'm really at a loss of how to proceed at this point.
I submitted proposed agreement as well, Your Honor.
The one at 627.
I believe so.
And that's the one I assume that Ms. Tina is in agreement with.
Correct.
Are you guys doing this right now? Or is that, I mean, is that what you're actually doing at this point?
Yes, Your Honor.
Ms. Tina, is that accurate?
Yes, Your Honor, except for the fact that the protection order is still on the kids, so I'm still risking my freedom at this point just to see my kids.
And I did submit removal of the protection order.
When is that scheduled for?
8/5/24.
Okay, so next Monday. Ms. Lawrence, have you received anything further from law enforcement at this point, other than what's in your report?
No, I have not, Your Honor.
Okay.
Quite concerning, Your Honor. The idea of the rights of the children to be safe in their own home versus what Commissioner Carmi's concerns of Mr. Olmos's Fifth Amendment rights. I understand those concepts, but at what point do the children get protected? Every citizen has an obligation to engage with law enforcement if they're called to do so.
Well, legally, they don't have to talk to law enforcement. I mean, that's an absolute basis. So I mean, I agree with what her concerns were.
And Your Honor, Karen had messaged me previously asking me to get in contact with Samantha. And in her message, she told me, I'm not supposed to be talking to you, but I'm going to talk to you anyways. And I want you to reach out to Samantha and let her know that the final GAL court date is still here. And so I completely was caught off guard because she told me to reach out to Samantha when there's a no contact order. And then she told me she's not supposed to be talking to me, but she's going to anyways. So I was a little caught off guard by the whole situation. I did not respond.
That's true. He did not. I contacted him to let him know that there was a court date, that you had suspended other court dates, but not the final GAL review. I did not tell him to contact Samantha, but that I knew that they were in contact with one another because that was evident, as Samantha had told me. I have not spoken to him outside of the guidelines of what law enforcement has prohibited me from doing.
Understand. I think what I'm going to do on this, I'm not going to move forward on anything today. I'm going to set this out. Part of the reason is this will be on, I assume, my docket on Monday to deal with the protection order, because at the moment that's kind of gumming things up to do anything under the case, whether it's 50-50 or whether the child would go to the mother or anything. So I think my thought on this is I'm going to set this over until I'm going to go over 2 weeks to the 13th. I'll take a look at the protection order hearing on Monday, on the 5th, and then I'm going to have to ponder how to move forward. Again, I've got a lot of concerns. I share the same concerns that Granted Litem does. And I think I just need to figure out how to move forward under what our ability to move forward is. Okay, so I'm not going to enter any orders today other than I'm going to set a review hearing in 2 weeks on the 13th at 1 o'clock, just like this. If you're set on for Monday the 5th to have the protection order moved out, is that 9 o'clock on the 5th?
I believe so, Your Honor.
It's either 9 o'clock. If it's 1 o'clock, it'll be me. If it's 9 o'clock, it'll be Commissioner Carmy. But that, assuming that's removed, then that takes one of the kind of sticky issues that kind of ties what I can and can't do until we get that out of the way. So with this one, I'm going to set it out to the 13th for review.
Thank you, Your Honor.
Okay, so I did note that the protection order was terminated last Monday, so that is no longer in place. And I do have the Guardian Ad Litem report from Ms. Lawrence, which obviously raises some concerns. And then I understand the parties have come to a different agreement that would not be necessarily consistent with that. So, Ms. Lawrence, before we proceed, do you have any other comments that you'd had about this case at this point?
Just that I'm very concerned that Mr. Olmos hasn't engaged with law enforcement, and the little kids are still in his household, and I find that disturbing.
Well, the two things is that I don't know that I have any ability to order him to do anything with law enforcement specifically.
May I say something, Your Honor?
Yes, sir.
Your Honor, I love my children with all my heart, and I would do anything and I can for them, and I would never endanger their lives. I've been a consistent father for 9 years. I've done everything to support them and give them a loving home. I've been consistently a dad in their lives. Since COVID, I've worked from home and I've been with them 24/7. I love my children with all my heart, and I just pray that you allow my children to have both their mother and their father equally in their lives. I just wanted to say that, Your Honor. I apologize. It's nothing fancy or, wordy or anything. I just wanted to spell out my heart to you. Thank you, Your Honor.
Thank you. So, and Ms. Tina, I see you have logged back in. Are you with us on this case?
Yes, I am, Your Honor.
All right. So, and you received a copy of Ms. Lawrence's report?
Yes, we did. May I say something as well?
Sure, go ahead.
So, as I've already told Judge Evans, our children have been through enough trauma. I know that George is not a danger to his young children. I don't know what's going on regarding the investigation and him complying with law enforcement. I just know that he's been a good father to our children. So I think that our children have been through enough trauma, and I don't feel that they need to be taken away from their father. I mean, they've already been through enough with having their mom taken away for 10 months. Do I wish I knew what was going on in the investigation? Absolutely. All they know is what I can go off of, really.
All right. And you've, Ms. Lawrence, you've not received anything more from law enforcement. They've essentially asked you to not proceed. Is that my understanding?
That is correct. I have received nothing more from law enforcement, and the allegation is so credible from Ms. Tenna's 13-year-old that is just terribly concerning. More so, as I detailed in the report, what Mr. Olmos's response was to it when he was questioned about the allegation from Ms. Tenna's daughter's biological father, and that really should be considered.
Miss Lawrence is lying, unfortunately.
Well, Mr. Ormos, I don't have any reason to believe that, as she may have a misunderstanding about something or something like that, or perceive something differently, but that's
possibly
appropriate.
Yeah, I apologize, but that's incorrect, Your Honor. I apologize.
What are you folks doing right now with the kids as far as contact with both of you? They're with you, sir, or is Miss Tina seeing the kids?
I had the restraining order lifted. So since the restraining order has been lifted, I lifted the restraining order on me as well. So she's been seeing the kids, yes. It's the kids love her, you know.
Miss Tina, can you tell me what that's been like since last Monday? Or whenever that was done? Your contact with the children?
Well, Your Honor, like I already stated prior, I was seeing the kids even with the protection order on. But it has been a weight lifted off my shoulders. It's not something that I have to worry about. The kids are fine. They're happy. They're 3 and 4 and 9, and they're 3 and 4 and 9-year-olds. So they cry, they are happy, they make up. They just it all depends on the day. But they're not in danger, and they're not unhappy. And they get fed, they get clothed, they get showers. Getting the 2 youngest into school soon, hopefully.
Ms. Lawrence, are you aware of any activity on DCFS or DSHS on this case?
Yes, there was an open case, and so as a result of that, we can't get any records until it's closed, and I have not been notified of that.
A current case with our local office?
Yes, it started with the law enforcement thing on Easter.
So I think you folks are in kind of an unusual spot, a kind of a legal quandary that puts the court in. It would seem to me that to move forward on this case, I mean, you folks have some agreements as far as your contact with the children on a short-term basis. I kind of need to see the outcome of the DSHS, DCFS investigation and proceedings as to what their plan is. If they're planning on moving forward, that impacts this case. If their decision is they're not going to move forward based on whatever they're going to make that decision, that changes things a bit. They haven't obviously filed anything because I haven't, at least not that I'm aware of.
That's correct. Unfortunately, we commonly get caught in that loop between CPS and law enforcement. CPS will sometimes wait for law enforcement, and when nothing's happening from law enforcement, CPS will just kind of sit on it for a little while, and then they'll review it in a few months and then toss it out as non-responsive if law enforcement doesn't come up with anything. I don't know what to do with it, Your Honor.
I understand. I understand. And I obviously have got concerns based on everything that's in your report, as well as this is a concerning case. There's a lot of issues that on the other hand, if parties have come to a certain level of agreement between themselves, which court has to consider that at some level. My thought on this would be to put this out a bit. Maybe if there's any possibility you could re-inquire of DCYF or DCFS as to what their status on this case is, to advise the court. And then I'm not inclined to make any changes. We haven't had really a hearing to hear from all the parties. I mean, I could schedule a hearing. I'm not sure that that's going to be particularly useful given what I know what everybody's position is, I think. But I'd like to see if we've got some kind of response back from the department.
I'm happy to do that.
If you
We'll
could-
see if we get a response. I've been particularly slow on getting comments back here in the last 4 or 5 months.
Well, and we are in the middle of summer. And I thought, why don't we put this maybe like the 10th of September? I'll give them an opportunity with some kind of a deadline that we're going to be reviewing the case and determining how to move forward. In this case, it would be very helpful if the department's what they're moving forward on or not.
Okay, sounds like a plan to me.
Okay. So, Mr. Olmos, Ms. Tina, I'm going to leave you kind of in the status quo you're in. You're working together, obviously, to have contact with both of you and the kids. I urge you to continue to do that. I just don't think I can move forward on a final decision on this case, even by agreement, without at least getting some input back from the department, since they have an open case. So I'll have Ms. Lawrence reach out to them, see if they can give us a status report as to whether they're going to move forward or if they're dropping their case or whatever they're going to do. And then I can hopefully come up with a better answer. Okay.
Sounds good.
Sounds good. Thank you, Your Honor.
Okay.
Thank you, Your Honor.
I'll set this at 1 o'clock on the 10th of September for review. Hopefully an update. Afternoon.
Good afternoon, Your Honor. Apologize for being late.
When we left last, I think you were going to check and see if there was any update from DCYF. Did you find anything else on this case?
Nothing from DCYF, still an open case, and Detective Sergeant Jenkins indicated that she was going to make another pass at Mr. Olmos's attorney to see if he could get an interview. And if that failed, that she was going to sit down and talk with the prosecutor. And that's all I know at this point on that.
Okay. All right. Thank you.
Mhm.
I'm really not sure what to do with this case. If the parties have come to an agreement as to what they want to do, obviously the courts has some concerns, the guardian has some concerns. I don't know if the state of Washington, I show them as being involved in this case, but I don't believe I've seen any pleadings.
Your Honor, at this point, the state is not involved, but will be once again if child support issues are raised or if there's a change in primary custodian. At this point, the state has withdrawn. We're just watching the case to see if it would reappear.
All right. So it looks like there was an order of support entered in April. And did the state approve of that order?
Your Honor, is this the joint custody order?
This is the order that entered April 9th. I don't believe this is a joint custody.
I'm not asking for any support.
Your Honor, the state did sign off on that order.
Yeah, we had put in an order for 50-50 custody and sole decision making to be 50-50 as well. That's all we've been waiting on, honestly, this whole time.
I don't know, does the state have any issue with that order?
If child support ends up modified due to that, then the state will appear again. At this point, the state doesn't have anything to add.
Okay. All right. So again, I do have court has some misgivings about this case. However, I don't know that I have any real mechanism to do anything. The parties have come to an agreement. Whether or not they choose to present some sort of agreed order is kind of up to them. There's other things happening in the community which may result in a change in the future. At this point, and I recognize, Ms. Lawrence, that your concerns are certainly, I'm not minimizing those in any sense. I just don't know what other path forward we have at this point.
Difficult case for sure.
So, Mr. Olmos, Ms. Tina, if you have some agreement and you wish to enter agreed orders to resolve this matter.
We already did, Your Honor. We
Yeah,
already entered the
I'm not-
50-50.
There's been no orders entered though. So
We submitted them to the courts, to the court clerks, and served them to each other.
do you have those?
I think a month and a half, 2 months ago. I'm not exactly sure. I'm terrible with dates.
Okay, I do not. You may need to resubmit those because I don't have those, and my clerk's indicating she's not aware of where they might be. So at this juncture, I mean, if you want to present those, I don't know that I have any ability to not move forward with them. And then if there are other legal proceedings that ensue, either through the police department or through DCYF, that may reopen this. So
Okay, we can resubmit them.
Right, that wouldn't require an additional hearing at this time. I would indicate on there that the guardian ad litem is not in agreement with that plan. So we have that in the record. All right.
Well, that's what we need to put in there. As you said, is that what I'm understanding correctly?
Either you can write that in or I can put that in when I see them. And if those come in, those should come to my attention because I'm not sure anybody else would want to dig through the file to figure out what's going on here.
Gotcha. Okay.
And Ms. Lawrence, it looks like we did approve your fees. Are those your final fees or did you have additional?
Those should be final.
Okay. So I would, if orders are presented and I do approve those, I would indicate that this was not the GL recommendation and that you would be discharged at that point.
Very good.
All right. I believe that's all we have today. And so
Thank you.
You're
Thank
welcome.
you, Your Honor.
Thank you, Your Honor.
All right. And did you both receive Ms. Corey's report?
I did, Your Honor. My office was closed Friday, so I was able to review it yesterday. I would like a little bit of opportunity to file a response. And wondered if the court would be willing to set this over a week or two so I can review the report closer with my client and respond to it before the court makes additional decisions.
Let me check and see here just a second where we left this. The last motion, we had a hearing on the second, and that was really just an issue about fees.
What's odd in this situation is that both parties filed motions for temporary orders last fall. The court really hasn't made any decisions on the temporary parenting plan or child support. The parties have brought it back before the court a few times, but none with a new motion. My understanding or my notes from the last hearing was that we were again asking for a temporary parenting plan and child support, and the court set it over to today so that we could have the input from the GAL before the court made any decisions.
And you're asking for some additional time, is that what I'm hearing?
Yes.
Okay. Ms. Gilmore, what's your position on that?
And I think we need some stability and answer from the court, particularly pertaining to summer visitation. If the court notes the GAL is recommending my clients have 2-week periods, I did confer with Ms. Corey and she indicated that that would apply to this summer. So, but for that time-sensitive issue with the fact that the children or the oldest child will be returning to school presumably in the next 30 days, I wouldn't necessarily object to a set over. I would want an order from the court providing my clients some time in Arizona, which we could potentially argue today and defer to other rulings at a later date.
And I guess I would request at least a 1-week set over because I didn't have time to review that. I didn't see the GAL report until yesterday, and it is asking that the kids go to Arizona for 2 weeks within the next 30 days. That was not something we had anticipated. So I would like a chance to respond to that before the court makes a decision on it. These are pretty young children.
All right, why don't we do this? I'll set it over 1 week. That I know the report did just come out. We looks like we got it 7:26. So that's fairly, last Friday. And I mean, in reviewing the report, it doesn't seem at all unreasonable, but I guess I'd like to hear from both parties, specifically with regards to the summer visitation, because we obviously need to address that ASAP.
For the record, I understand the court's ruling about the set over, but my client is looking to have visitation August 12th to the 26th. I have conferred with Ms. Powers about that. It does allow the opportunity for that with the set over. It's just costs are going to be substantial. So I just need to note that for the record. My client is asking from the 12th through the 26th.
Okay. Well, assuming that there's nothing that convinces me otherwise, that's likely to happen. But
Okay.
we'll assume that's the case unless there's some gigantic issue. I mean, it seems reasonable given the circumstances, but again, there's a lot to flesh out here, and it is time-wise, that's pretty quick, but we'll take a look at it on the 6th at 1 o'clock.
Thank you.
Thank you.
Okay, and if you come to some agreements, that's always fine with the court as well, but we'll take a look at it on the 6th at 1 o'clock. Just right there.
Thank you.
You're welcome. Okay.
And I believe it's Ms. Powers' motion.
It is. Go ahead.
Thank you, Your Honor. Before we get going, I had a preliminary issue. Ms. Winkles served our office with a motion to strike our reply declaration and also several supporting declarations that we received yesterday afternoon. I would ask the court not to consider those filings. Ms. Winkles alleges that we've raised 4 different new areas in our 2-page reply declaration. I don't believe that's correct. As I reviewed our reply declaration and as I prepared our reply declaration, we were simply responding to the allegations in Mr. Everdale's responsive pleadings, which included substantial attachments, more than 20 attachments to his response declaration. So I would ask that the court consider our reply declaration and not consider the additional pleadings filed by Ms. Winkles yesterday. As the responding party, she should not have had a SIR reply anyways, and she provided another declaration from her client along with 2 supporting declarations. Not only does that violate Local Rule 88, the context of those pleadings raised new issues that really aren't relevant to the issues in front of the court today.
Ms. Winkles?
Yes, Your Honor. We actually put in an objection first, and that objection was because there were new issues raised. In fact, in the original declaration of Ms. Powers' client, she essentially said nothing bad about Dad. Suddenly, Dad had a whole host of problems which he couldn't answer to. I listed those problems out in the objection. I was very clear in the objection that I'd asked for those things to be struck from the record. In the alternative, Dad should get a chance to respond. The whole idea of having the SIR reply of one of the moving parties is so they can answer questions, not so they can raise new issues. Clearly, there are new issues about romantic partners, not at all in the first declaration of Dad. Allegations of spying, again, not at all in the first one. Mental health, suicidal ideation of Dad, not at all in the first one. And about payments of debts. The debts, I can understand Ms. Powers' statement that she was essentially just answering, and it's stated in the first. The first 3 are absolutely nowhere in the first one. Dad would have no ability to respond. That's not accurate. That's not supposed to be how it's going to happen. I'd ask that if Your Honor doesn't strike those things that she speaks about, that you actually allow my client to have a SIR reply. We've limited it to 4 pages in total. Very short declarations. There are text messages attached, but those are exhibits, don't count in the page number. We've tried to keep it very, very short. And just to respond to those issues, no additional issues are responded to.
A brief reply, Your Honor. The 4 issues Ms. Winkles alleges that Ms. Everdale brings up in her reply declaration are: 1, information about romantic partners. Mr. Everdale's responsive pleadings spend a lot of time talking about Ms. Everdale's romantic partners. They list 3 potential men that she's had relationships with. They file extensive criminal history about one of these men. We were simply responding to that. My client does mention in her reply that she had concerns about Mr. Everdale in terms of him spying on her, and that's how he obtained many of the documents he attached to his responsive pleadings. And she makes a statement about his mental health, not for the core issue of the court finding he has mental health problems, but to explain why she had Mr. Owana living in the home with her. I believe that that's appropriate in that context to include in the reply declaration. Lastly, Mr. Everdale alleges that we've put forth a new system of debt payment, and that's not correct. The same proposal that we made in our reply declaration for splitting the debts is the same proposal we made in our motion for temporary orders. We were just reiterating that that's what we were asking the court for. And then just lastly, I would point out that the two supportive declarations that were filed yesterday don't address these 4 issues. Instead, they spend time talking about my client's instability and attaching a lot of text messages that frankly are not relevant to the issues that we have before us. We have text messages about my client's interference with her son's wedding planning. Really, it just clogs up the record here and is not relevant to the issues in front of the court.
So when I reviewed the case, there's a lot of information throughout the case that's not particularly relevant to the court's decision in the case on temporary orders. And so I'm not going to strike the reply, and I'm not going to necessarily consider the SIR reply because it was outside of the timelines. The issues that are complained about are not issues the court sees particularly relevant to the issues before the court today. So.
Thank you. With that, Your Honor, can I go ahead and make my argument?
Sure.
Okay, we're here today on some pretty limited issues before the court. The first being the parenting plan. Parties only have one minor child left between the two of them, and this son, Adrian, will turn 18 in October. My client is asking that Adrian be able to decide where he lives, and that both parties have joint decision-making until he turns 18. Currently, Adrian is living with his brother and not with either party. We also have the issue of child support. Again, since the child is not living with either party, we ask that both parents supply the proportional share of education expenses. Adrian is involved in running START, and so there are some expenses involved with that. We have provided clear information about the mother's income. The mother grosses $54,088 a year. That's over 10 and a half months. We filed the mother's pay stubs with the court on June 26th. Additionally, Mr. Everdale filed her employment contract as Exhibit T to his declaration filed with the court July 16th. As you review the employment contract, it's clear on that contract that she's employed for 10 and a half months of the year. So when you take the $54,000 divided by 12 months, her gross income is $4,507.33. I believe there's no dispute about the father's income. He receives VA disability and Social Security benefits at $5,249.88 per month. So we're asking that the transfer payment be zero, but that each parent pay their proportional share of running START costs for the child. The next issue is the family home. My client is in the process of moving out of the family home. The father stopped residing there in about May, and the child also stopped residing there in May. We're asking that this home be placed for sale and sold as soon as possible. Mr. Everdale has been paying the mortgage. In his pleadings, he asked to be reimbursed for mortgage payments and utilities. We asked the court to reserve on reimbursement. That can be decided at finalization. But we would ask that in the meantime, the house be listed for sale, and the proceeds from the house sale should be kept in one of the attorney trust accounts until further order of the court. Next, we have the issue of personal property. I believe that the parties are in agreement that the mother will continue using the Dodge Dart, the father will use the Subaru Ascent, and the child will use the PT Cruiser. There's some debts between the parties. We are requesting that each party pay off half of the personal loan and half of the American Express card. The parties just sold a joint piece of real estate together. It was a lot that's attached to the family home. Both parties received about $88,000 from that sale. And so we're asking that each party pay off half the balance of personal loan and the American Express card to just have those debts taken care of. The only other remaining debt would be the mortgage and the car loan on the father's car. We ask the father continue to pay his car loan and the mortgage. Again, the court can reserve reimbursement for mortgage payments and utilities for later down the road. And I believe that those are the issues before the court today.
All right. Ms. Winkles?
Yes, Your Honor. So the child does turn 18 very soon in October. The issue is the child will still be in school until June. He needs stability. And the reason he's not living at mom's house, and it's not actually mom's house, dad is living there too. And so we need to kind of talk about this. So both parties are actually living in the marital home. My client's father just lost his wife. So my client's mother passed away just very recently. He also broke his back, his father. So my client has been essentially staying and helping his father out for a few weeks at his home, at the grandfather's home. But that's not where he lives. All of his stuff is still in the marital home. He literally went over there for a few weeks. And you can see that in some of the text messages, specifically Exhibit N, which shows that as of June 24th, mom and dad have both agreed that dad still lived there. And she states, you need to move out. And he says, I'm going to try to move out. In any event, this child needs stability. The one who is best placed for stability, this child in the last year of high school running start, is dad. Mom moved in Mr. Owana. Mr. Owana had moved him in after a month of knowing him. He has a conviction for incest. He has several drug convictions, the most recent being July 3rd. You'll see text messages.
Hold on, counsel. I have an objection.
I would object to relevance because my client is not suggesting that the child should live with her or Mr. Owana. Mr. Owana has a messy history, but I think it's really a red herring here and not relevant to the issue before the court.
If I can respond to that.
Sure.
Briefly. It is relevant because mom is asking for joint decision making. If mom's decision making includes bringing home a sex offender to a house where a minor child lives, that definitely goes to her decision making ability and her ability to make decisions that impact the best interests of the child.
Well, you allow some limited. I've reviewed the record. It's not horrendously relevant to the decisions before the court today. But go ahead.
Okay. Essentially, mom has brought in a number of men. But again, we're not chastising mom for that. What we're saying is the child needs to have stability. The child didn't feel safe in this house. The child moves to the brother's house. Doesn't necessarily mean the child wants to live at the brother's house, and it doesn't mean dad wants the child to live at the brother's house. Dad would like to have the child in the marital home until it's sold. That way the child can have as much stability as he can. It's going to take some time to get the house up to snuff in order to sell it in any event. This allows the child to be with dad. It allows child to have stability. Dad is really in the best prime position to be doing this. All of his stuff is still in this house. Child would like to go back. Now, the issue of child support. We agree, the child's almost 18. Child should pretty much decide where he comes and where he goes. However, there is still a need to support a child. You don't, even though the child's at brother's house, it doesn't mean that their support is only running start. Wherever the child is, there's a child support need. There's a need to essentially support the kid with whatever he's doing with food and boarding and things like that. But if the child is with dad, then mom does need to be paying child support. And so we've actually calculated mom's income differently. We used her contract because her contract clearly states that she makes $64,000 annualized over the year. And this is because she obviously earns on a short-term basis. And so they annualize the income, which allows a comparison because that's what she's earning over the whole year. So I think that the way they're looking at the annualized income is incorrect. They're looking at her actual pay, but she works for 9 to 10 months, but she actually gets paid over the course of the whole year. So that's a little bit confusing. When you look at their incomes, they're almost identical. And we've put in our child support order to your honor, showing essentially that they are relatively the same in income. And that kind of gives us a few things. Number one, the child support should be paid by both of them. If child's in dad's care, dad's going to spend that money. Mom needs to pay dad support. Additionally, the other expenses, such as the bills, need to be split in half, and that's not what they asked for in their original motion. They asked for dad to pay all the car bills, dad to pay all the mortgage, dad to pay this and that. These parties make essentially the same amount of money. It seems ridiculous for dad to pay 3/4 of his money towards bills that they're both using, and mom just to have be flush with cash, especially since they earn about $400 from within each other. What my client is asking for is that all of the debts are split down the middle, and he's actually put them down on here. So we have a car payment of $595, the mortgage of $2,376, utilities of about $1,000, personal loans $728, credit card payment of $500. That's a total of $5,196 per month. If we split that, and how we split it was the husband's proportional share of 54% and the wife's of 46%, then they'd each pay relatively the same amount of their income. They'd have relatively the same amount of income to use to spend on their living expenses. We have also kind of done another little table where husband pays the car payment and half of the mortgage, mom pays half of the mortgage and the utilities, dad pays the personal loan, mom pays the credit card payment. They did sell that property, so it's up to your honor if your honor wants to use the funds of that, the asset, to pay those debts off, or if they should just continue paying the monthly amount. My client is fine either way. He'd prefer the monthly amount until we do an asset and debt spreadsheet to see where the parties actually lie on the assets and the debts in total. I think I've covered everything. The assets, obviously, my client would like to have possession of the house at this point, and the Subaru is sent. The Fiber Federal Account 4996. Again, we've listed that on a fair division of property. Now, normally I wouldn't do this in a temporary order, although this case is very few issues, and so we think it's probably appropriate to kind of separate out their debts at this point in time. We would just ask for, again, child support of about $613 a month to dad. Dad gets to stay in the home. Dad will fix it up. We'll sell it. That was dad's idea to start with. And that we separate the debts out so that they're equal because they both make the same amount. Thank you.
So I guess explain to me your calculation on her income, because
yeah, so her income is annualized, and in the actual the contract, the employment contract, it says the annualized income amount of $64,000 and some change. We use that amount and actually put it into the child support worksheets, which came out with her gross income of about $5,000, a little over $5,000, and her net income significantly less, but her net income was around say to 4,000. My apologies. Her net income was $4,552 was what we had it at, and that's based on her contract. Because while she only works for 9 to 10 months out of the year, she gets paid for all 12 months, and so that's what you're not seeing when you see that check. So it's actually a bit different income, and you can see her contracts.
Well, I have absolutely no idea what that contract means. It doesn't tell me whether she makes 54,000 or 61,000.
Your Honor, I can't let you know that when you take
That's what I'm trying to understand.
$54,088 and divide it by 10.5 months, which the employment contract explains that it's for 10.5 months, you get the same gross pay that is on her pay stub, which we filed on June 26th. And that is the $2,575 per paycheck. She's paid that twice a month. So my client's explained in her declaration, she grosses $54,088 a year, and that amount of money is paid over 10.5 months, not over 12. So that's why we took the 54,000 and divided it by 12 to get her monthly gross average.
I guess I'm not following. So she gets.
So if you look at her pay stub, let me pull a calculator.
I think I'm looking at that.
She grosses $2,575.67 per paycheck. She's paid that twice a year or twice a month. If you multiply that by 2, that equals $54,088 divided by 10.5. I know I did this math when I was putting the reply declaration together.
The issue is she's paid bi-weekly, correct?
No, she's paid twice a month. So if you multiply it by 2, it's $10,151.34.
Yeah, and it does say on the employment contract, it's $54,088, but it's annualized at 12 months at $61,816. And that's because in that 9-month, it is very confusing the way that that's written, but annualized is what you look at to compare a year. And that's because the income continues, even though the work income, that's what annualized means in accounting, is that you're stretching out whatever you get in 9 months, you're stretching it out to a year to compare. And it's often used to compare 12 months to 12 months. So I'm a little confused to why the annual salary says there $54,088. Although my guess is because while she's only working for the 9 months, she's actually getting paid for the full 12, which happens to teachers quite a lot. They end up getting less money per month over a longer period of time. That's why we use the annualized amount, because for comparison purposes. And that's on Exhibit T.
And I would agree that it's confusing, but it does say in parentheses, if she was working 12 months, then she'd receive $61,816, but she's not. The contract amount is for 10.5 months with potential overtime eligibility. And she's explained that that's paid to her over 10.5 months, the $54,000.
I don't see that in the parentheses. It says 12 months. Well,
Looking at the pay stub, I come up with $5,174 and 60 cents a month. And what number did you have?
I had that amount for her pay stubs, but as she's explained, she only gets paid 10.5 months of the year. So I took the 54,088 gross that she earns over a year and I divided it by 12 months, even though her whole salary is paid out to her in 10.5 months.
And I have the same amount as you, Your Honor.
I'm sorry?
I have the same amount as you. I have 51.51.
Right. So I guess my question, and then I don't know if my recollection, having had a couple of clients years ago that worked for the school district, they didn't get a paycheck every month in the summertime. They were paid the months that they were in school. But that may be, I don't know what this contract even means, frankly.
Well, in my client's declaration, she explained that her situation is that it's paid out for 10.5 months. So she's got a month and a half each summer that she does not receive any paycheck.
So that's accurate. Her annual would be 54,333.
And my client states that he believes she gets paid for the 12 months and that she gets paid a lower amount every month, which would explain the 51.51 when it's annualized. I don't have any problem. I don't know if Ms. Powers does in splitting the baby in half and doing it right in the middle at this point, just for a very short term until we can actually get more information from her employer.
Well, let me hear from Ms. Powers your response.
And well, I think the court has the employment contract, the court has her wage stubs, the court has her declaration that it explains there's a month and a half gap with no pay stubs. So I'm not sure what additional information would be warranted here. Short of filing bank statements that show she didn't receive deposits. I guess I could potentially get a letter from the employer that confirms she doesn't receive pay stubs for a month and a half.
Well, looking at the contract, it does seem to say that she works 10.5 months. But the contract is not clear whether it's 54 or 61 that she earns. And I don't have a W-2 form.
And that's the thing. She should have something from 2023, and there would still have been obviously 6 months in 2023 where she will have worked. Part of that being the summer. A majority of it would have been this summer, so we'd really see what her actual income was if we had a W-2. And that's some of the other additional information that she could supply. And we could just essentially cut it in half right now. It's not that much difference. I believe it's what, about $600?
Well, I think the difference is in our worksheets, it put dad just over 60% and mom around 40%. So in terms of a transfer payment, that could have an impact.
Well, I think on the issue of the incomes, I'm gonna set that over either a week or 2 weeks and get that clarified, because I can't make head or sense tails of the contract, what it's telling me. It's telling me two different numbers.
Could we set it 2 weeks? That'll give me a little bit of time to reach out to the employer.
That's fine. So put the financial decisions, or at least the calculation of her income, over to the 13th. And so I guess, Ms. Winkles, you're asking that Mr. Everdale move back into the house, she move out of the house, and then I guess
he prepared the house for sale. His stuff is all there. He's only moved a night bag out to go stay with his dad after his mom passed for a couple of weeks. All of his stuff is still there. He stays there when he wants. He comes in when he wants. We're asking that he essentially stay there with the child pending the sale of the house. They do need to fix it up. They need to remove some stuff, fix some things. I think mom's in agreement with that. Dad can work on that and do those repairs, get it listed. Broom clean condition. We have no problem with that being in the order, and attempt to sell it. It will take a couple of months to sell, but at that point, the child will be 18. The child will most likely, it's not going to sell to the beginning of the year. At that point, child's had a little stability living with dad.
Can I give a brief reply, Your Honor?
yeah, I'm just trying to understand what the request is, because that's what I'm trying to figure out here.
Thank you. My client's requesting that both parties be out of the home and it get listed for sale. She indicates that in her reply declaration that the parties have already talked to a realtor. The father and Adrian have not been living in the home. The best chance at stability is we know The plan within the next few months is that neither party will live in the home. Both parties should set up wherever it is they're going to be. And if Adrian chooses to live with his dad at that point, so be it. But it seems counterproductive to have them moving back in the home while we're in the process of trying to get everything out and sold and cleaned. We would ask for language that if the parties can't agree on a relitter and a process, that the relitter be the one who decide what, if anything, has to be fixed up before the house is listed and pick the price point and that sort of thing. But we'd like to get that listed and going.
And we have, we have no problem with some of those caveats of agreed realtor picks based on a CMA. We can even do, everybody does a CMA, choose the middle. We have no issues with the normal language included in a sale. But dad's stuff's already there. It's not moving back in. There's no moving stuff back in. There's dad walking through a door. That's the only change. And dad cleaning up the house. It seems foolish to have two people paying rent, two people paying, sharing a mortgage when one person can at least have the benefit of that with the child during the process of sale. It's not an immediate thing. It's not going to be an immediate thing. Yes, the parties agree that the house should be sold, but they also need to realize that the child does need stability until he's 18, or at least until he graduates from high school.
You have any response to all that, Council?
Nothing further, Your Honor.
Okay. So let me just, for clarification, Ms. Winkles, your client he's staying at his dad's right now?
Yes, Your Honor. Well, he's kind of floating. Oh, sorry. He's kind of floating back and forth. He's coming to the house. He's staying at his dad's. He's stayed at a friend's house a couple of nights. He doesn't really have a location. His dad did just lose, obviously, his wife. And so that's why he was there. He doesn't want to live with daddy. There's no air conditioning, I believe, at dad, or there's no television. There's something there that makes it quite difficult for my client to stay there. There's no room for the child to come there. It's not a permanent situation. Grandpa doesn't think dad's moving in. Grandpa thought dad was helping after his wife passed. That's it.
All right. I just wanted to clarify that. And your client has made arrangements to move, is that?
She is. She's in the process of moving out.
Okay. And do you know when that's going to take place?
She's working on it this week. So she has gotten a rental and is in the process of moving out this week.
Okay. So she'll be out of the house within the next 2 weeks?
Yes.
Okay. So, on a temporary basis, what I'll do, I'm going to have him in the house. And that should take place no later than the 13th, which is 2 weeks from today. He can make the house payment. As far as the other debts, I mean, he would be, I guess how were the utilities $997?
I think that includes their telephones, and I would imagine that includes their telephone.
Like cell phones or?
Cell phones, yeah, their cell phone service. I think they're all on the same cell phone package still. I believe it also includes, there was one other, insurance, car insurance, but mom did take herself off of car insurance, so I don't think that is on there any longer, although they do have car insurance for the children. They pay for all of their children, including their 2 adult children.
Okay, well, she's gonna have to pay, rental wherever she's at. I don't know what that. So I don't have a good gauge as to how to divide up the debts. I mean, he can pay the mortgage. He's gonna live in the house. Pending sale. I assume the utilities for the house. I don't know about if there's cell phones. That's a separate issue.
I believe my client would agree that each party pay their own cell phone.
And then there's the question of the children and splitting. I don't know if they want to split it 50-50.
I don't know what the bill is. I don't have that information. So is the car payment for whose car?
That's my client's car. But he drives it. The other one they paid off. So that his is the only one with a bill on it.
Okay.
And there's a credit card payment of $500 per month and a personal loan of $728.
Okay.
And dad is also currently paying car insurance for all of the children, because mom did take herself off.
How much is Zach's? I don't have that here.
I believe it's on here. I don't actually have that information.
Okay, so well, let's do this. We're gonna set it over 2 weeks for calculation of mom's income. I'll take a look at the financial issues. We give you some clarification as to specific monthly bills and what her living expenses are gonna be as far as rent and that sort of thing. Then I can come up with an equitable division of the debt on a temporary basis.
It seems fair.
Assuming that the child wants to live back in the home, he would be with dad and the mom should be paying child support to dad. If the child remains living with the other child, they both should be paying child support to the other person. So we need to, I guess, understand what he's going to do, if he's going to live in the house with dad or if he's going to stay with the brother.
What would be the best way for the court to get that information? I know that Mr. Everdale had suggested appointing a GAL. I think that that seems overkill, given that we've got 3 months. But would it be a situation where family court could be appointed for the sole purpose of talking to Adrian and finding out what he wants?
And Your Honor, I would suggest just an evaluator on a brief appointment, somebody just on the GAL register that can talk to him for 10 minutes.
Well, I could appoint our investigator. That would not cost the parties anything, and we can get a fairly quick report from her.
Perfect.
So let's do that as far as kind of where he's going to be on a temporary basis. This is probably one of those cases where he's going to make his decisions about how much time he wants to spend with each parent. And I don't know that anything I tell him is going to have a whole lot to impact that. But we'll point Jen to take a look at it and give us a feel for if he's going to live there, if he's going to live with the other child. And then when we come back in 2 weeks, I can look at the dollars and cents of that.
Would the court want to set this all over? Do you think 3 weeks would be enough time for family court? And then we could just deal with it all in one swoop?
Look, Jen, let me see if she happens to be on here. See her listed. I would think 3 weeks it would be probably, well, I don't want to do 3 weeks because I'd either go 2 or 4 because I don't want to stick this on somebody who's covering. So
I would be fine with 4 weeks.
you want to come back on the 27th for everything? With the understanding she's going to be out of the house by the 13th. He's going to be in the house by the 13th and then.
Correct.
And that works then.
Okay, so let's do that and then we can address everything at that point.
All right. Thank you, Your Honor.
All right.
Thank you. And will the court do the order appointing family court, or do you need one of us?
If you could do that, I'm going to be here for a little while still, I know, on a couple other matters. Of course, you're going to be here as well, I think. So,
I bet Ms. Winkles and I can get one out to you tomorrow.
that'd be perfect.
Yeah, absolutely.
Yep. And that could be sent electronically to me.
Okay.
That's good. Thank you, Your Honor.
Okay, thank you. You know, I want to apologize to the parties because I did see some emails come through, and then when I look at the file, that information had escaped my memory. So I didn't have a chance to really look at this until the last 2 days. So, and I did that. And I guess I overlooked the fact that you were looking for some response back, and that's my mistake. And so let me get to my notes here.
Your Honor, the state just filed a notice of appearance in this matter.
Yeah, okay. I didn't see that.
It would have been yesterday, late in the day, so I doubt it's in Odyssey yet.
Okay. Well, that's probably why I wasn't aware of that. So at this point, excuse me. So at this point, when I looked at the questions, I looked at both parties. Ms. Wylie, did you receive her declaration as well?
I did, yes.
Okay, that was not filed with the court. It probably should be since I did look at it. Probably not critical. Everybody's looked at it. So when I did the decision, when I looked at Ms. Blaglio's income, I determined that to be a net of $2,850. So how that gets calculated as far as taxes applied or anything is really not an issue for the decision on child support because the $2,850 is the number we use. The 3201, which let me see here. 3201, which is dad imputed at 40 hours. That's the number I came up with when I ran through the numbers. As far as the taxes, the way the taxes are done currently, the fact you've got 6 exemptions doesn't make a whole lot of difference, apparently, according to the tax tables. And what I am inclined to do in this case would be to set the impute income at 2801 net based on 40 hours. Currently, the deviation would set child support at 285. That would go back to 10/1 of 23 forward, because that's the first of the month following the filing of the case. And then at this juncture, I'll adjust that to the 220 a month. And that may change depending upon how that all assumption is. We have 2 healthy twins.
They've been born, they're
Yep.
alive.
Oh, okay.
Yes.
Okay. So that would be 220 from the month after they were born, whatever. Was that this month?
Yeah, they were born, I believe, on the 17th of July. So
So
220
that
beginning
August 1st, it
1st.
would go to the 220.
Great. And then I think I only had one other question left as I was drafting orders. I'm also drafting a contempt order right now, and I didn't have any notes whether the court made a finding that Mr. Walker's failure to pay daycare, whether he had been able to follow the orders or was not able to follow them. So I wasn't sure which box to mark on that order.
Looking back, just a second here ago, he would have had the ability.
Okay.
Yeah.
I think I've got all the information I need
Yeah.
now to draft these.
Okay.
Would the court want to set just the presentation over 1 week? And then I know we were also on today for review of the GAL order, and Mr. Lawrence has asked for another 30 days. I have no objection to setting the GAL piece over to the first week of September or second week of September, whatever works best for him.
Do we have that? Just a second here. Mr. Lawrence, or is he present? There he is.
Yeah.
Screen there. Where are you at as far as your?
I met with both of the parties, Your Honor, and what I'm waiting for, there are allegations that there were CPS complaints in the past, and I've requested those records and I haven't received them. And a lot of times it takes up to 45 business days in order for them to respond. So I'm hoping sometime in the next couple of weeks, I should have that information.
Okay. So if we were to put this into the first week of, excuse me, last week of August, first week of September.
Let's do the first week of September, Your Honor, because I don't know when I'm going to get the information.
So the 3rd?
That will work for me.
Okay. Let's get the other order presented. We could probably do that next week. Do you want to just do on this docket?
Yeah, that works.
Just be simpler. So, and I see Ms. Bleglio is present. So Ms. Powers will send you a copy of that order. We'll come back. If it looks okay with what I just said, we'll come back next week. And if you don't think it says what I just said, then we'll talk about it on the 6th. If it looks fine to you, let her know that, and then I can enter that order as soon as everybody's agreed to it.
And I did also receive the notice of appearance from the state. They have medical language they're requesting. I will include that in the order.
Okay. Did you receive that information, Ms. Bleglio?
No, I didn't.
Okay. The state generally requires certain language to be included in any child support order, which is a part of the statutory requirements. I don't have that in front of me. I'm sure they can send that to you. It's not something I have a whole lot of discretion about. So it's probably in transit to you right now. It was just filed yesterday here, apparently. So it's just some statutory language that goes in the child support. It doesn't change any of your rights or anything like that. Okay.
Okay. I don't think I fully understand what you guys are talking about, but.
Okay. Well, the state gets involved in these cases, and there may be some language missing in your old order. And what this would do is it would put in the current required statutory language requiring medical payments, that's medical insurance. So they'll send that to you in case you have any questions about it, and then you can contact them directly if you have questions.
I see. Okay.
Okay. All right. So we'll come back next week on the 6th for presentation.
Thank you.
And then back in September for Mr. Lawrence.
Thank you, Your Honor.
Thank you. And I reviewed through a lot of documentation, including, did you both receive Mr. Lawrence's report?
Yes.
Okay. So let me hear from you all where we're at today.
Thank you, Your Honor. We have two different motions pending. One is my client's motion for a temporary restraining order, and one is Mr. Diaz's motion to begin family counseling. Additionally, we're here to review the GAL report. So I don't know how the court wants us to tackle these. I think reviewing the GAL report is incorporated pretty well with both of the motions.
I agree with that. I did have a very late filing. It was filed yesterday morning. It was a response to the garden ad litem report by my client. I sincerely apologize to the court. I've informed Ms. Powers as to the delay with my other half of my work, the criminal defense work, having to be in the jail twice as much because of requirements for attorneys to be there really.
I don't know that I saw that, but the last thing I had was a July 18th filing from Ms. Hawkins. I don't think I saw anything additional.
I filed it at 8:30 yesterday morning.
Okay, so I wouldn't have that. If you want me to have to look at that, I could.
It was mostly just highlighting things that were already in the guardian ad litem report that we wanted to draw attention to.
Okay. And did you receive that, counsel?
I did, Your Honor.
Okay. I haven't seen it, so I'm not sure what all is in there, but if you want to talk about it, I suppose that's fine.
All right.
Okay.
Thanks. Well, if it's appropriate, I'll go ahead and begin. We've got two issues before the court. One is my client's request for a temporary restraining order. And then the second is Mr. Diaz's request to begin family counseling. I think the easiest place to begin here is that we've received the GAL report. And at this point, my client is in agreement with beginning reunification counseling. So not quite the same as the family counseling that Mr. Diaz laid out in his motion, but my client is in agreement with beginning reunification counseling and either doing that virtually or coordinating with a Texas counselor. My client does want the kids to stay in Texas. The guardian ad litem report supports the children staying in Texas at this time period, but it is time to begin the reunification counseling. We are also asking the court to adopt the guardian ad litem recommendation. And those include that neither party disparage each other. The GAL does a good job of laying out the history here and the mistrust that exists between both parties in this case, and frankly, also the children. So we're asking the court to adopt his recommendation that Casey remain the custodial parent, that the children remain in Texas for now, that Casey have sole decision-making, that reunification counseling begin, and that all contact between Mr. Diaz and the children be under the guidance of the counselor, that both parents stop making derogatory remarks about the other, and that the court review this again in 90 days to determine what effect, if any, reunification counseling is making. And so we would ask the court to adopt those GAL recommendations. I believe that our request for a temporary restraining order goes hand in hand with these recommendations. We've submitted for the court that Mr. Diaz has gone out of his way to try to make contact directly with the kids, even though the current order from the court is that the kids stay with my client and no visitation occur until we got more information from the GAL. Essentially what has happened is that Mr. Diaz on his own went to Texas and attended Dylan's high school graduation. Now he says he did that because he as a parent had the right to be there and wanted to be there and support her. That may be true, except that Mr. Diaz went out of his way to text my client, Ms. Hawkins, who already has quite a fear of him based on the extensive history in this case, and let Ms. Hawkins know that he was there attending with his family. Had he not sent that text, my client would have never known, the parties wouldn't have known, he could have enjoyed the celebration and it would not have impacted. But instead he went out of his way to text my client, and then later that day happened upon Dylan's graduation party, which was being held at a friend's house outdoors, and had flowers delivered, and also sent a follow-up text, making sure it was clear to everybody that he had sent those flowers. Now, sending flowers may seem innocuous, but given the history here and that he hasn't had healthy contact with the kids in over 10 years, it felt really threatening. And it sent the message that he knew where they were, he was watching, and he was going to insert himself. Even though we had this GAL process pending, even though we know that there's been a long history of non-involvement, it was shortcutting the process here. Then we file our motion for a temporary restraining order. Mr. Diaz is put on notice that those steps he took on Dylan's graduation were upsetting to Dylan. And what does he do? He gets a hold of Dylan's cell phone number and he texts her directly. We filed the text for the court. In those texts, he directly texts this daughter, who he has not had a relationship with, and says to her, "I comprehend the severity of the psychological abuse you and King have endured and the lifelong effects it has." That is completely inappropriate in the context of what his relationship is with Dylan, and if anything, took a huge step back away from reunification. We need the court to enter a temporary restraining order to ensure that Mr. Diaz's contact is controlled by the reunification process and that he's not just able to show up on a whim when he feels like it. He's not able to just send messages when he feels like it, but instead that this all be handled by a trained counselor who has experience in reunification and can give this the best shot of success for all involved. So we'd ask the court to adopt the guardian ad litem recommendations and additionally enter the temporary restraining order. Thank you.
Okay.
I'd first like to start by addressing the restraining order. We're asking the court to not enter it. We're asking the court to deny it. First and foremost, I think that it is unnecessary if the court is going to write some sort of language in a temporary order to monitor and govern the communication that happens between the children and my client. My client in his declaration said that he did have every right to be there. He is somebody who's been trying to connect with his children and had an opportunity to go watch a monumental event for his daughter. He learned of this information of the graduation from the guardian ad litem. He has connections to Amarillo, Texas. His grandparents live there. He has family there. And so he went. He was able to get tickets. He was able to go. It was pure happenstance that he came upon the graduation party. And given the monumental day, this big moment, he wanted to celebrate his daughter, understanding that there is a status quo order in place at this point. There was nothing saying that he couldn't contact Dylan. The restraining order has criminal consequences. I think that it's over the top. It would make it more difficult for whatever reunification process happens to move forward. It would require multiple parties to sort of operate within this document. And again, there's criminal consequences to it when it can just be simply written in language in a temporary order. The text provided by Ms. Hawkins in the declaration, it's not a full, complete conversation. There are texts after that that are missing that we really think would be, we didn't get a chance to provide those to the court because we didn't get a reply to that. But in short, my client got this phone number from a pleading and was able to, something that Ms. Hawkins provided, and that's where he got the phone number. It was no stalking, it was no funny behavior, nothing along those lines. So again, we're asking the court to deny the restraining order and instead create some sort of language within a temporary order to govern that communication. The important things that I want to address with the guardian ad litem report and the motion to begin family counseling is, my understanding is that reunification counseling is a pretty rigid and structured process that can't happen when the parents live in different states, when the children live in different states than the parents. That's one of the biggest issues we have from the beginning. This is an issue that Ms. Hawkins created by leaving the state when there was a pending case. We have in the guardian ad litem report now documentation that shows the extent of the alienation that has occurred, that is creating a lot of this hostility of the children toward my client. And there's a big concern about whether or not online counseling would even work if they can't be candid outside the presence of their mother. If it's happening on Zoom, there's no way to ensure that Ms. Hawkins isn't going to be there watching, monitoring, and doing whatever else, not giving the children an opportunity to be there and have those conversations on their own. This is the same concern that we have about the guardian ad litem report as a whole. The investigation at this point has only been virtual as it pertains to the children. There's been very minimal contact with the children. The report says that Mr. Lawrence hasn't had any contact with, I think, either of them since April. Yet this is a document that's going to be given a lot of weight, and the investigation, in our opinion, just simply is not thorough enough at this point. Bringing the children back, at least on a temporary basis, solves a lot of those problems. It helps them get set up with counseling. It helps them talk to the guardian ad litem more seriously without the presence of their mother. And my client has stated in his declaration that he's willing to pay for accommodations. If that's truly the barrier at this point, bringing them back at least temporarily, he would be paying for the accommodations, or he offers to. So in closing, we obviously agree that reunification counseling should start. I think we disagree on how it should start. We think it should start as soon as possible, and we do think that the children need to be here to get that started so that we can coordinate that. And we do also agree that there should be reviews occasionally set to see the process.
Okay. Any response?
Does the court want to hear from the guardian ad litem before?
I do. I'm going to hear your response first and hear what Mr. Lawrence has to say.
Thank you. Just briefly, Your Honor, in regards to the restraining order, Mr. Diaz lives in Washington. My client lives in Texas, and yet Mr. Diaz keeps showing up and interrupting and inserting himself. We do think it's absolutely necessary that the court enter a temporary restraining order. That restraining order can have the exception in it for whatever contact is at the discretion of the reunification counselor. We think that's appropriate, but given the last year in this case, Mr. Diaz has shown that he makes contact when he wants to make contact, even despite the fact that they live half a nation apart from each other. So we would like that restraining order entered. And I believe that reunification counseling can be done and coordinated between two counselors. If the concern is verifying that the children are having counseling without my client present, I think that there's a couple different ways that we could do that. We could coordinate between Ms. Rosen's office and a counseling office in Texas, and that counseling office in Texas could have the children present without Ms. Hawkins and can confirm that they met with the children without Ms. Hawkins. Alternatively, we could get feedback from Ms. Rosen's office about whether or not she is comfortable starting virtual counseling or not. But I think that there are options here to get this going without the kids being present in the state of Washington. Dylan has just graduated high school and is getting ready to start college this fall. It's a disruptive time in her life to have to come travel up to Washington to get this process started. And frankly, reunification counseling can be a slow process. It's going to start with the counselor and the kids working together. And there's no reason that can't be done from Texas.
Mr. Lawrence, do you have any thoughts, particularly with the process in handling reunification counseling?
Yes, Your Honor. I had a very similar situation in a previous case where the father was living in Oregon and the mother was living in Hawaii. And the father had requested somebody that was licensed to provide that kind of counseling in both states. And no licensed counselor, there was no way we could find anyone who was licensed in both Hawaii and Oregon. And so what we settled on was to have the father arrange for a counselor in Oregon to work with him, and another counselor was arranged for in Hawaii to work with the mother and the child. And then the two counselors would work together in order to try to facilitate the reunification. It is more cumbersome, but it can be done.
Okay, thank you. All right, so this is a really complicated case for a variety of reasons, and it's been essentially in front of me since its inception quite some time ago. A lot of hearings reviewed, an enormous amount of documentation in this case, and frankly, there's a lot of concerns that I have after review of that. And it's really, I mean, I think Mr. Lawrence's report, I'm fairly comfortable with that report based on what I've experienced in handling this case up to this point. What I'm inclined to do, I'm inclined to adopt the recommendation in Mr. Lawrence's report, and that's encapsulated on page 3. I would add an additional line in there that the only contact between the father and the children should be through that process. I'm disinclined at this juncture to enter the no contact order just because of the extra layer of challenge that presents. Assuming that he does not follow the rules of this order, then that would be certainly be something I would look at though. But I mean, everybody's got to act in good faith on this thing. I think the idea of trying to accommodate the long distance counseling, I think it's obviously a challenge. There's time differences and, but I think what I would like to do is have the parties work through Mr. Lawrence or with Mr. Lawrence to find some counselors who the guardian believes are appropriate. I'm going to leave that up to him to kind of give the thumbs up or thumbs down to a particular counselor. So, and I don't expect Mr. Lawrence to be heavily involved in all this, but I want to make sure that we have somebody outside of the court who can kind of keep an eye and make sure that everybody's following through and we're getting that put together. I think the review in 90 days makes sense. I think I'd like to see a review maybe in a couple of weeks, just to make sure that we have the process getting started on both ends. So maybe on the 13th, I'm gone the 20th, but I can either the 13th or the 27th.
I would prefer the 22nd if it's okay. I have a 3-day trial that's supposed to go the week of August 13th, although I can make it work if I have to.
27th?
I'm fine with any of the dates.
Okay, well, let's put it on the 27th, and that'll just be really to make sure we've got everything kind of up and running. And when we have that hearing, at that point, we could probably just do a presentation order at that time as well, since, we're just adopting the report with the additional line that Mr. Diaz needs to follow any communication through this plan. And at that point, let's go 90 days out from the 27th in hopes that we can have something at least set up. So we're starting to move forward at that time. And Mr. Lawrence, are you available on the 27th? I didn't ask that.
Yes, I am, Your Honor.
Okay, great. And I think that should cover.
Would the 90 days be November 26th?
Be in December, actually, because I'd go 90 days from the 27th. December, and that's going to put us right in the Christmas holiday, which is probably, let's review it before that.
How about the first week of December?
The 3rd.
Sure.
Let's take a look at it the 3rd. That's about 90 days out from today. And in part, depending upon where we're at, I may want to do some kind of orders over the holiday. We'll see.
All right, sounds good.
And I had one question. So in our motion to begin family counseling, we made some requests about including some language for Ms. Hawkins to make best efforts to have this process work to make sure the kids get to their appointments. We have some significant concerns based on especially the GAL report and the alienation that is described there, possibly being unwilling to comply.
I'm assuming you've had a discussion with your client about following through. And I think language that both parties shall use their best efforts to facilitate the process makes sense.
Okay, I'll include that.
Your Honor, I have one question for clarification.
Yes.
We are talking about reunification counseling, not family counseling. Is that correct? Because they're two separate things.
They are, and I think the first one has to happen before the other, actually, to some degree.
Agree.
I mean, if we can get over the hurdle of reunification process, we're probably going to be looking at something additional down the line.
Thank you.
Okay. So let's do presentation then on the what did I say, the 27th?
Yes.
27th. 27th, and then we'll review it in December and go from there.
Thank you.
Right.
Thank you, Your Honor.
If you all agree on an order, you can send that electronically as well.
Okay,
You get the whole
thanks.
thing.